Joan Rivers died recently, and her daughter Melissa is contemplating bringing a lawsuit for medical malpractice and wrongful death. But wait a second, what if there's no conscious pain and suffering? Can she still go forward with a lawsuit? You want to know the answer? Come join me as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now, in every wrongful death lawsuit, one of the biggest components, one of the biggest part of the case is pain and suffering. But what happens if the injured victim didn't suffer any conscious pain and suffering? Can you still go forward with a lawsuit? And let me tell you, you can show pain and suffering even if it's only for a few seconds, for a few minutes, for a few hours, days, weeks, even months. That's still possible to include within a claim for wrongful death. However, what happens if the wrongful death occurs while the patient is under anesthesia during a surgical procedure? Is there any conscious pain and suffering? Now that becomes a challenge, it becomes a big problem. Why? Because according to the news reports, we know that Joan Rivers underwent an endoscopy, right? And in order to have the endoscopy, you have to have anesthesia. The doctors typically will use a medication known as propofol, and that puts you to sleep. So now, if the wrongdoing occurred while Joan Rivers is asleep during the procedure, and now she suffers massive cardiac arrest, respiratory arrest, suffers massive brain damage, can you make the argument, as the family who's now bringing a lawsuit, that now she did suffer conscious pain and suffering, that she was aware of what was going on? Well, the defense will obviously turn around and say, hey, she was asleep. She was under anesthesia. There's no possible way she could have been aware of what was going on to her and recognizing the tragedy that was unfolding in front of her. So now, according to the news reports, after she has her cardiac arrest and respiratory arrest, she now gets transported by ambulance to Mount Sinai Hospital, where she remains in a coma for the next 8 days before her daughter Melissa removes her from life support and she dies. So, assuming that there is such massive brain damage that occurred, and now she's in a coma for the entire duration, the 8 days, can you still claim pain and suffering? In New York, in order to justify a verdict for pain and suffering, the surviving family has to be able to show that they are more likely right than wrong, that there is some evidence, some conscious level of awareness of the pain and the suffering that she's going through. Was there evidence that she was moaning or groaning? Did she respond to painful stimuli when the doctors did a neurological exam while in the hospital? All of those things will lead to the conclusion that she must have had some evidence of pain and suffering. Did she respond to people's voices? If the brain damage is so significant, it becomes an ironic catch-22. So now the family argues, hey, you did a horrible thing, you caused terrible harm and ultimately her death. But then the defense turns around and says, yes, we're sorry that that happened, but it was such a bad injury that she really didn't have any conscious level of pain and suffering. So to answer the question I raised in the video, can you still go forward with a lawsuit? The answer is yes, you can, because there are other elements of damages that you can try and obtain, even if you cannot show successfully that you are more likely right than wrong, that there was some evidence of conscious awareness of all the suffering and all the pain that she was going through. You know, I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, there's something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.